know why. I don't even know why we're here.
We're just talking about these things.
Nothing I can do on the felony case, man. I'm just a lowly misdemeanor.
In his defense, Judge, the felony motion is based on technicals, and in this new case, this failure to ID.
Really?
Yeah, I don't see anything.
Well, let's do it real quick and then we can talk and I can give you more info.
On March 21st, 2025, officers were dispatched to a family disturbance call for service at 2525 Holsworth Road in Spring, Harris County, Texas, which is an apartment complex. The officer began by identifying the defendant, who could not provide a valid driver's license. The defendant verbally identified himself as Adam.
Classic fake name move, except in Texas, that's not just a bad lie, it's a crime. Failure to ID during an investigation? Misdemeanor. But here's the twist. He eventually cops to his real name. So why's he still in cuffs? Because the law doesn't care if you fess up after lying. That first false statement, that's all they need.
Mitchell, with the date of birth of December 23rd, 1987. The reportee then gave the officers his correct name, and the defendant then admitted to providing false information due to advising about it that he believed he had. The defendant then gave his correct name. The officers discovered an active warrant for the defendant out of Cook County, though there was no extradition.
So there was a Cook County.
There was, but there was
Cook County, Illinois?
Yeah, sure. I looked at the NCIC. All I saw in there that it could possibly be was some sort of like traffic offense.
Okay.
That's all the trigger he's talking about. Don't say
Not right. So he gives the name of Adam
Mitchell. And Judge, this isn't filed as a fugitive, just to straight.
because he wasn't. Well, maybe he was. I don't know. Regardless, so Mr. Walker, I'm going to find that there's sufficient probable cause. Well, hold on. I'm going to find that there's sufficient probable cause to go forward in this failure to ID case. It looks like
call the police.
I don't want to call the police. They never asked me my name.
I don't.
Like, I'm the person who called the police.
Was this? I thought it was a stop.
No, they
No.
were dispatched to a family disturbance at an apartment complex. The officer arrives, proceeds to try to identify both individuals, began by identifying the defendant, who could not provide a valid driver's license. The defendant then identified himself verbally as Adam Mitchell with the date of birth of December 23rd, 1987.
I mean, I get that you call the police, but nevertheless, I mean, we've got.
Then he told them the right info.
But you still gave the wrong info, and then they looked them up, and then they get, So, I mean, there's enough probable cause to go forward.
Why would that didn't happen, but why did, if I call the police, why are they asking for my ID in the first place? They don't have the right to do that, sir.
They're going there for a disturbance.
Yeah,
They have to, look, I can't get into all that stuff now, but they're to investigate something that happened. There's a disturbance. They go there. Normally what officers do is they have to look at everybody who's there to determine, hey, who is this? What's going on here? Does this person have any kind of issues? And, regardless, the good news is that it looks like on motion to revoke, the only thing is fees that I see in this case, okay? I can't let you go at this time because this is a felony warrant. You're set at no bond now, but you'll get to felony court on Monday, and at that point, I'm sure that they'll do something. I'm not gonna,
That's crazy, man. I called the police.
I'm not gonna.
A couple fighting, and I just called the police. That's all I did, sir. I seen two couples fighting, and I called the police because there was a guy hitting a woman.
I can't give you legal advice.
She's writing everything down too that you're saying. Maybe later
Just
down the
don't
road,
say
you might
anything at
want to
this
say
point.
something
You
different.
can talk to Mr. Pons. I'm not putting any conditions on your bond. Just be careful, Mr. Walker. Okay, thanks.
What was our bond? And this one, it's PR bond, right?
Yeah, he's got a PR.
No, I bought that for $1,000.
So you're.
That's right.
Yeah.
6,000.
I'm here on Miss Gill. She's set for a bond today, and
Is she in
so
custody?
she is. Yes, Your Honor. And she has one pending felony, but she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI's at 1,000. Yeah.
Okay. I talked to
Unless it just gotten said, I don't know.
Okay. Is it a PR bond?
No. It's a
Okay.
show.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy, you going? Do you need a translator?
No.
Do you mind me bringing up Ms. Gill? All right. Good morning, Ms. Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Oh, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Drive in Tarrant County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road.
Hold on. Colored? Did this defendant just drop a 1950s-era excuse while facing felony charges? Ma'am, hungry and colored isn't a legal defense for hitting someone's car twice, and with her gore record, assaulting an officer, injury to a child, and now evading, the judge's patience is thinner than her credibility.
And the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant,
you telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt. Finish.
I'm so sorry.
Finish.
I'm a commercial driver. Okay.
You, if you do have a CDL,
That is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally because allegedly hungry and covered. So now this is an affidavit, and I hope that you take it seriously, because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive. I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother, has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so, as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know if anything they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always how many people died this week.
Boom. The judge drops the hammer. When reckless driving becomes a public safety crisis, the courtroom gloves come off. A 5K bond hike, a driving ban, and a brutal reality check. How many people died this weekend? This isn't just about her. It's about protecting everyone else on the road. Mike dropped.
And on the road because of the reckless and wanton actions. All we want are our streets to be safe.
You're not helping me. I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this, okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. If I was a different color, you would. And it's true.
That's so not.
It's so true. And you know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm going to do. I'm going to leave your bond at $1,000 now. All right. I'm not going to raise it to 5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. That's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new case.
Yes, sir.
And just, all right. Let's do this. I'm not going to do anything until this lawyer gets here. All I know is he's got 3 open cases. They're all at 7503 because you continually take off. You come to court when you want to come to court. You don't come to court. Let's wait for your lawyer to get here and we'll see. But all I know is you've got 3 open cases. All the bonds are 7503, which indicates to me that you've taken off 3 different times. So let's see. So just take a seat for me. I'm not going to argue with you. I'm going to wait for your lawyer to get here and then we'll go from there.
Okay.
But you're supposed to come to court when the reset says, not when you want to come to court.
No, he told me not to come to court, Judge. He said not.
You can come to court, right? But you're supposed to come to court when the reset says. And we have multiple instances of you not doing that. I don't know how else to say it. So let's wait for your lawyer to get here and we'll go from there. Just take a seat.
Judge, I'm already.
Ray, ready? How are you? Who do you want to talk about first?
Let's do Lestrap.
Okay. Come up, Mr. Lestrap.
So Judge, there was misunderstanding on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is a beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received a letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrap, you've now picked up a 3rd theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
Yeah, she at home.
Did you come with mom today?
Yes, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrap, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move. Ray, I'm sorry. I'm not going to give another PR moment. Perhaps, I don't know, but you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at.
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you, though. 500.
Appreciate it. Here today?
We have quite the, did you represent him before?
No.
We have quite the history with this gentleman
Okay.
where he's had a couple cases in here with numerous bond violations. He pled not too long ago, or no, I think, did it get dismissed or did he plead? I don't know.
One of them pled and the other one got dismissed.
So he's now picked up a new case. All I know is that he's charged with evading arrest. He picked up a new case on the 30th. And we've gotten emails stating that because of this case, I think he broke his leg in half, is what he's saying. He broke his knee, his tibia, fibia. I don't know. He's provided Victoria some kind of paperwork. I don't know if it's legitimate or not. It appears to be, but I was going to do probable cause number 1 to see, was there really an injury that occurred? I don't know.
It says he tripped and fell. The officer indicated that he tripped and fell as he was running.
Yes.
Please.
On December 29th, 2024, an officer observed another officer driving through a parking lot of 2901 Westridge Street with emergency equipment on and chirping sirens due to a large crowd loitering on the property with no loitering signs. The officer observed in the left side mirror the defendant toss an object underneath a motor vehicle on the property. The officer made a U-turn and observed the defendant reaching under the same motor vehicle, retrieve the object, and reach into his front waistband as if placing the object. The defendant then tossed the object under another motor vehicle. The officer wearing full uniform told the defendant to come towards him and asked what he had dropped. The defendant walked towards the officer, stating he did not drop anything. The officer grabbed the defendant's left hand and attempted to handcuff and defendant took off on foot. The officer chased the defendant, and the defendant tripped on a drainage. The defendant evaded for approximately 100 feet. The officer looked underneath the motor vehicle and retrieved an unholstered black Glock. The defendant was identified by his Texas driver's license.
Did he suffer an injury as a result of that trip and fall? Does the officer notate? Because from what the email says is that he went to the hospital at that time. Is that what that says?
Didn't say anything in the DIMS.
No, and it does not say anything regarding whether he was taken directly to JPC or whether he was taken to the hospital. This is a Houston Police Department case, so we do have the offense report, so I can...
Do you mind looking it up real quick?
Yeah.
Maybe just the DIMS doesn't say it. The emails that we've gotten is saying that he's in such pain and such dire circumstance that he cannot make it to court. But I have quite the history with this gentleman where...
Yes, so he was taken to the hospital due to a leg injury. He was taken in an ambulance.
Let's say that.
Yes, Judge.
Okay. So I've appointed you to represent him. If you don't mind reaching out to him to see how bad is it, when can we get him here, how, and we'll go from there.
I did see he has felony on the 30th, so I'll see if I can get in contact with him and find out if he's going to come to that, and if so, we'll just do it the same day.
Yeah, I'm okay with that.
Okay.
Okay, great.
Okay, perfect.
That way you can, now, one more thing. In the past, he has also emailed me with a bunch of stuff before. So when you reach out to him, don't email. It's been quite, just please.
Yes, sir.
Yeah, okay. I think that's it. I think we're done. What? Oh, on
Approbation, and I'm not sure. Garrett is one of them. I want to see if this is a race.
yeah, I remember. You said Garrett? All right, Mr. Lestrap, it looks like you've worked out an agreement. Come on up. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, they know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk. Your every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. Don't go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days.
Yeah.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this? Guess that's it, right?
Yes, Your Honor. I talked to him. He understands the nature of the consequences. Has no means of being able to afford bond, so we can look at the newer case. So he's opted to take the agreement on the old case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, then why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. You're giving up the right to, well, have I gone through the warnings? I don't remember. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right? Good luck. Or did he say plead guilty?
Yes, sir.
I didn't hear it.
How do you plead to the offense, sir? Guilty or not guilty? All right, I'll find you guilty, sentence you to good luck. Thank you so much, Ray.
Good morning, Judge.
Hi, please. Of course. It's been a while. How are you? Good to see you. I'm so sorry. So much drama up there. It's just too much.
It is, but you know,
Down here, it's, you know,
where they put me is where I go.
I get it.
I'm here on Ms. Gutierrez, Sandra Gutierrez.
Come up, Ms. Gutierrez. Either you have a problem or you just don't care about court orders. It's one or the other. If you have a problem, I'm going to address it for you. And I promise you, you're not going to like the way that I do it. Do you understand? I'm now going to put an ankle monitor on you. And if I ever find that you test positive again for anything, and I don't give a rat's behind what it is, you will stay with me. And if it becomes an extreme case, I can have a hearing to hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a lockdown rehab facility. Do you understand? If that's what it's going to take. I'm amending the conditions now to put a scram on her ankle. I hope, above all else in this short life, you are not driving. Because if it comes to my attention that you are in violation of this affidavit, it's really not going to go well for you. You understand?
Yes.
Okay? All right?
Now, Your Honor, we do have an offer, and we wanted to run it by you to see if it was something that you'd take. It is a jail offer.
So, Your Honor, it was, yeah, and this was I didn't see it, but yes, it was a minimum of 30. I think we just didn't realize she had 10 days credit, so it wouldn't be a time.
How does she have 10 days credit?
But I didn't run her, so that's good.
That's what she did let me know. She has about 10 days credit. So we can verify.
254. I don't know.
It's just
She has 1 day credit.
1 day. How'd you get 10 days credit? That's okay.
I was in jail so I was on probation before when I caught this new charge. I was actually did a 5-year probation and I was supposed to sign my papers that day that I was, I guess, exited out of jail, the day that I left jail. And
Look,
it was like a week before, so yeah.
Please.
I'm not sure.
Just, you guys talk it over. I don't want you to say something that really hurts your case. So it's probably better that you just talk with each other and figure out what you guys, we only have 1 day credit here. That's all we have. If you want to, I'm happy to do it.
That's good, Judge.
If you guys want to do it.
The 1 day, Judge?
Right, well, she has 1 day credit. I'm not going to give her more than she's entitled to.
I understand.
You know, I can only give you what you're entitled to,
Yes,
right?
Judge.
What you have here. So if you want to do that, you have my blessing. It's up to you guys.
That's
You let me
Sounds
know.
good,
But as of today, if she leaves here, she gets an ankle monitor. Plus, and then if you test positive again, it's not going to go well for you. Okay?
Sounds good. Judge,
You let me know. Yes, ma'am.
does she have to go back in here, Judge?
No, but she's got to meet with pre-trial.
Yes, sure. On Ms. Sandra,
Yes.
we have a new offer, probation officer, 15-month offer with a TRAS. Whatever the TRAS states that she should do, she'll do it. Sounds good?
Absolutely.
Sounds good, Judge. Thank you. We'll write it up.
Here's the thing, though. She couldn't even make a felony probation. How's she going to make this one?
She didn't make felony probation.
Did she make it or did she get adjudicated?
She completed it, 5 years.
Tell her that if she tests positive, I will put her in a treatment facility though, so she knows.
Yes, Judge.
Warrant is fair warrant.
Yes, Judge, and she did.
Absolutely.
Yes, Judge, I'll let her know.
Ma'am, on which one? Ms. Gutierrez, you're charged with driving while intoxicated. It's a second, am I right?
Yes, Judge.
What happens the next time? If you ever pick up another DWI, what's gonna happen?
It'll be a felony.
2 to 10 in the penitentiary. Any prior pen trips?
Yes, Judge.
How many?
Just one.
You could be
14.
potentially a 15 to life case next time you pick up a DWI. 15 to life, minimum. With your record, just the mere smell will be enough. So if you want to get lit, wonderful. Just don't get into a car. Find another way. Take an Uber. 30 to 50 bucks will get you wherever you want to go in this city. No matter where you want to go. Anywhere. Do you understand? It's not hard. One button. All you need to do is literally push one button. Car waiting for you, wherever you want to. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning back. Do you understand? This will go on your record. It's going to be there for the rest of your life. Now, is it being reduced to a first?
Yes, Judge.
There is a surcharge that you will be required to pay in this case. You will be required to pay a $3,000 surcharge, and if you don't pay it, every $100 you will sit 1 day in jail. Do you understand? It's a second, I'm not waiving it, and it's being reduced to a first. You were lucky because a second, it's a $6,000 surcharge that if you don't pay, 1 day, every $100 you owe. So you will be required to pay this fee. You will also be required to pay the court costs as well. You have entered into an agreement where they're offering you 180 days in jail to be probated for 15 months. As part of the agreement, you will do a repeat offender DWI education class, 1 victim impact panel. You will do a TRAS to see what other conditions you may need. If they assess other conditions, you must fulfill them. They may do inpatient, intensive outpatient treatment. They may do just supportive outpatient treatment. They may do inpatient treatment. I don't know what they're going to do, but you must fulfill whatever they say. Do you understand?
Yes.
No drugs, no alcohol, guardian interlock. But since you don't have the ability to drive, you must get a portable device, 25 hours of community service. Do you have any children? Get rid of the community service. I'd rather do a parenting class. $100 one-time donation to Mothers Against Drunk Driving. If you need extra time to pay, we will give it to you. All you have to do is ask. I'm telling you now, there's 2, 3 possible things that could make this thing really go sideways. The first is if you drink. If you consume, a warrant will be issued. They will file a motion to revoke your probation. We will have a hearing here. If they prove it to me that you're consuming, it's very well possible that we put you into inpatient treatment. The other thing the worst possible thing you could do is drive. If you drive without a Texas driver license and a liability insurance, likewise, they will issue a motion to revoke. The other thing is take off. If you abscond and you take off, it's an instant warrant. If you ever have an issue, you can come talk to us. We can work it out. There's never nothing that can be solved. Everything can be solved in this life, one way or the other. Those are the 3 things that are all hangups. Do you understand? So cut her fees. How do you plead to the offense of driving while intoxicated, guilty or not? Is there an accident in this case? No? Okay, fair. All right, ma'am. Best of luck to you. We'll have you meet with Shori.
Thank you, Judge. Be excused. Thank you, Judge. Good to see you again.
All right, so I see that you're wanted out of Bucks, Pennsylvania on a parole violation. 2 underlying cases.
So the fact that he's been on the same fugitive case twice more in your court works both in and against my favor. Before my time in general litigation, there were 2 prior other prosecutors.
Here we go, flexing the muscle.
Well,
I'm just
one of
kidding.
them was me. But for the 2 prior ones were dismissed, and he keeps getting arrested on the same warrant, and they keep not picking him up. I had Amy call the...
This is going to happen eternally for you, Mr. Ginder, until you go back to Pennsylvania. you will continue to get arrested over and over and over. It doesn't require you to say anything. I'm just giving you a heads up that that warrant will be there for the rest of your natural born life until you take care of it. If you're 72, you will still get picked up and sit in jail for, how do we go forward?
So this is one of those unusual situations. There is no pre-signed waiver, so he has a right to.
A parole case?
Some states, including ours, they just don't have it in their clause for their parole. But I've had Amy call, and she was only able to reach the supervisor for the deputy that actually handles his specific warrant.
Dave, don't we have enough people in jail, number one? And if they don't care enough to pick them up over and over.
So one of them, I was explaining to Ricardo, the first, and I could be wrong, I haven't checked my notes, but one of them might have been around COVID. And so I know a lot of them were picking up. Nobody can fault for that. But the other ones, I don't know. And that's why I'm saying, like, I'm not trying to present anything to court that I don't have. But conversely, he's had considerable amount of time to cure his warrant. And so that's why I said, like, it works for and against me is obviously I don't like them playing games.
You want?
For me, I would like to get a hold of the supervisor there and figuring out what happened the other times, but we've just been unsuccessful this morning. And that's the issue.
I get it. Do you want to perhaps roll it to tomorrow? So it gives you enough time? Hey, I'm with you.
I know.
It's maddening that someone continues to get picked up and they don't care. Either release the hold or come do your job. Really?
Because we do have ones where they release it locally, where they teletype that they won't enforce it in certain jurisdictions or just contiguous ones. And so I don't have an answer to present the court. I mean,
let's roll it to tomorrow. We're going to try to get to the bottom of it, Mr. Gimbel or Ginder. But regardless, that warrant, until you take care of it, is going to eternally be out there forever and a day. And if you like to continue to get arrested, but at some point it must get tiring, right?
Yes, sir. All right, we'll roll it to tomorrow.
So let's roll it to tomorrow. I will tell you this, that I mean,
I know, and that's where I'm at as well. And so I'll see if I can I'll keep going up the chain until somebody answers. That's all I can do.
Yeah, good luck, Day. I know how diligent you are.
Hey, Judge.
Thank you.